Why might your will be invalid under Washington law? There are a lot of reasons, but first of all, let's focus on formalities. Your will must be witnessed. The signing of your will must be witnessed by two people who are not related to you and who don't inherit from you. So if you're signing your own will and you want your kids or in-laws to be the witnesses, bad idea. That's going to be an invalid will. When it comes to a notary, the notary is actually notarizing the signature of the witnesses and to make your will a self-proving will, such that upon your death, those witnesses don't have to go into the courthouse and testify that you were competent and knew what you were doing. So the notary is notarizing the signature of the witnesses to make it a self-proving will. Why else might your will be invalid beyond these formalities? Let's say you decided to change the terms of your will after you executed it. So you started writing and you started crossing things out and you started adding things. Just those revisions to your will could cause it to be invalid because we don't know what you meant by changing things. Or did you actually change things, or did somebody else come in and make those changes? It's unclear. So any kind of handwritten changes to a will are going to be a red flag and potentially cause your will to be invalid and not honored. What else might cause your will to be invalid? It could be that there's a claim of undue influence, that really what's in your will and your wishes aren't yours, that somebody else had such influence over your life and that you were so vulnerable to their persuasion that you are making a will that really isn't what you wanted, it's what they wanted. And this often happens when people have diminished capacity and they have somebody in their life who is looked at as having more influence over you than they should have. Other reasons that your will might not be valid is that you lacked the legal capacity to understand your will. You didn't know what your assets were or who your family was, or that you're at such a point because of cognitive decline that you don't have the legal capacity to execute a will. Interestingly, under Washington law, testamentary capacity, legal capacity to sign a will is the lowest level of capacity that is required when you're signing documents. A contract requires more understanding than signing your will. Signing your durable powers of attorney requires a higher level of understanding than signing a will. How can you make sure that your will be honored? The best way is to go to an elder law and estate planning lawyer who will be standing behind your will. Number one, they'll make sure that all the formalities are met. That should go without saying. But number two, they'll make sure that if there's any possibility of undue influence, that they're aware of it and they're going to ensure that there isn't undue influence. Or when it comes to a claim that you didn't have capacity, you want the attorney backing up your estate to say, no, I met with this person, they understood what they were doing. Yes, perhaps they had a diagnosis of Alzheimer's or other dementia, but having dealt with people with diminished capacity, an elder law attorney will stand behind the will. If they were a part of its preparation and execution, they're not going to allow somebody who lacks capacity to sign a will. So you want an attorney standing behind your will.